Any mention?
Yes. May it please, Your Lordship. I beg to mention for an urgent listing for tomorrow, my lords. This urgency is that, my lord, there is an order of the Board of Revenue, my lord, which has put me in a very precarious situation. Now, this was an appeal filed against an order of the Public Premises Eviction Act and Unauthorized Public Premises Act. But, my lord, there's a suit pending. And, well, I have a very bona fide claim. I have documents for the last 40 years. So, my lord, my argument is that, my lord, when
That you are coming by way of what?
by revision, my lord, by way of revision, against the order of the Board of Revenue, my lord.
Against the order Board of Revenue is revision lies.
Revision lies, my lord. Earlier also revision was filed, my lord. I'll satisfy lordship. I'm making a prayer for tomorrow. Much obliged.
I'd like to mention item number 5, my lord. We need some more time to do the hearing, my lord. Is that relating to the forest?
No one is appearing for the respondent.
Yes, my lord.
On prayer made on behalf of the
State petitioner.
yes, on behalf of the state petitioner. Yes. This is a matter of 3 weeks.
3 weeks, my lord.
Yes.
Lordship, I beg to mention item number 4, Lordship.
Yes.
Yes, sir, the matter may come up after 3 weeks, Lordship. It's POXO matter quashing.
No objection, Your Lordship.
Okay. On prayer petitions, list after 3 weeks. Yes.
Obliged, Your Lordship. Please, Lordship. Lordship, I beg to mention item number 6. I've taken consent from the respondent, Lordship. I've taken consent from the sir. Item number 6. It may come after 2 weeks, Lordship.
Some difficulties. Item 6 on the prayer made on behalf of the petitioner, list after 2 weeks. Yes.
Highly obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 3.
Yes.
Your Lordship, it's a joint request. Your Lordship, we pray that this matter may come up after 3 weeks.
On joint prayer made with the parties, list after 3 weeks.
Much obliged.
Item number 1.
Please, Lordship, this is at the stage of consideration of delay in filing the revision application. There is a delay of 84 days, Lordship, and a show cause has been filed by the respondent here. Here, Lordship, what had happened is the petitioner here was the defendant in a title suit which is pending. And at the stage of evidence, she wanted to adduce defense witnesses. So she filed an application to allow her to adduce additional DWs and also to exhibit photocopies of treasury challans which were relevant in the matter. So that was, Lordship, rejected on
At what stage that prayer was made?
at the stage of evidence itself, Lordship. That was rejected. Why? Because there was a change of counsel in between before the trial court, and the counsel there, Lordship, prayed for an adjournment, saying that he has only received the copies lately. But that prayer was rejected, and the amicus case was.
What is the delay? Just come to the delay.
Delay is 84 days, Lordship.
What for delay? What is the reason? Delay?
Lordship, 2 reasons was one, Lordship, that because of the change of the counsel and the financial problems, and because there is a delay of 84 days, Lordship, and some time taken to get the certified copies of the.
Yes, Mr. Khera.
My lord, our stand over here is, my lord, that they have filed a miscase for condoning the delay of 84 odd days. But my lord, they have given very general reasoning over it. They have not given any proper satisfactory reason for the delay. And my lord, the law is very settled that mere making any averment for the reason of delay is not sufficient. They will have to substantiate on the same.
In my paragraph 5 at page 4, Lordship, that is the essential explanation, my lord.
My lord, they have merely stated that there was a financial burden. My lord, they have not given anything to substantiate it, and what the litigation shows that this is a long litigation which is going on.
Now, how financial constraint be proved by supporting document
My
or?
lord, they could have obtained an income certificate if so required. What I am saying is, it's a mere averment they have made, and also the delay in approaching to take the certified copy.
Heard, Mr. Dev, Learned Counsel, appearing for the applicant. And also Mr. Khera, Learned Counsel, appearing for the
Single respondent, Lordship.
respondent. Stop. Paragraph by this application. The applicant has sought for condonation of delay of 84 days in preferring the civil revision application against. Where is the judgment on order?
Lordship, please, that is in my revision petition. Lordship, the certified copy is there on the top, dated 13/2/25. It is also there at page 32.
Against the impugned judgment order. It is order.
It's an
Order.
order, Lordship.
Impugned order dated 13/2/2025.
In miscase number
Passed in miscase number 80 within bracket capital H of 2023, arising out of title suit number 7 within bracket H of 2017 by the impugned order dated 13/5/2000 passed by the learned assistant district judge Shillong in miscase number so and so so and so. Okay, this details you will get in the revision petition on the cost.
180H of 23.
Stop. Paragraph. The reason for delay in preferring the reason for delay is stated to be because of due to financial constraint of the applicant. See, what the requirement of law. See, normally this revision should have been filed within which date?
90 days, Lordship.
90 days means from which? Within,
From the date of the
okay, from the date of the 13 to when 90 days expired.
Lordship, 90 days would have expired in the month of May, Lordship. The 13th
See,
May.
if you see the law requires that you should give a reason why you could not file it within that period of time.
Lordship.
Now, if you say 90 days from 13 to,
Lordship.
it would have expired
On 13th May or so.
April, May.
May, Lordship.
Sometimes in May, isn't it? 10th or 11th May, maybe.
Here, well, what I have tried to state is that after the order was passed, he has tried to deliberate with his counsel as to what can be the legal recourse, and thereafter, on the month of April, 2nd of April, he has applied for the certified copies for the purpose of filing a revision. And thereafter, Lordship, that was, it took about 2 months to get the copy.
Has been treated with financial questions, and also that the certified copy of the impugned order, and also that the the certified copy of the impugned order was supplied to the applicant after a long period of delay.
My lord, para 5 of their petition, my lord. That is where they have tried to explain the delay. My lord, even if we see the period which they say after obtaining the certified copy till filing is a period of more than 2 months, my lord. There they say that is the time taken for them to obtain the signature. The financial constraint was a part they attribute to the period until applying of certified copy.
Financial constraint was before obtaining certified copy and then again after obtaining certified copy.
These things, my lord, practically
Anyway,
they
Mr.
happen,
Khera, you
Lordship.
know,
Because sometimes it takes time for the petitioners to be convinced also. So.
I'll leave it to the court.
we'll take. But just say what's needed to you. Okay. Stop. The paragraph. The respondent objected to the side explanation on the ground that the same is not supported by any evidence, and the statement appears to be non-specific as to the dates on which the the present counsel was engaged by the applicant. And when the revision petition was made ready for hearing. Stop. Paragraph. Upon hearing the learned counsel appearing with the parties, and on perusal of the materials on record, it appears that apart from the contention of the applicant that there was a financial constraint, what you said, just it appears that apart from the, it appears the certified copy of the impugned order dated 13/2/2025 was supplied to the applicant only on 18/6/2025. Though the same was applied on 2/4/2025. Stop. It is therefore clear that the delay in filing the connected revision petition was also due to the reason which was beyond the control of the applicant. Stop. The reasons for delay stated in the application, thus is found to be appears to be, and thus the The reason stated in the application is thus found to be satisfactory. And the prayer made in this application is allowed. Stopped. The delay of 84 days in preparing the connected revision application against the impugn order dated 13/2/2025 is hereby condemned. Stop. Registry is directed to diarize the civil revision petition and list it for motion.
Obliged. Obliged, Lordship.
Hearing item number 2.
This delay is obliged, Lordship.
But this is again that matter, my lord. I was praying if this matter could be taken at the end of the board, my lord.
Why at the end of the board? There are hardly few matters today before this court, Mr. Papa.
Just some difficulty with the senior counsel.
Take your time and make next week.
Mr. Khan,
Lordship.
in this matter,
Lordship.
court would like to go a bit deeper in the sense that the plot, forget about the claim of the petitioners, just for the time being, keep it aside.
Lordship.
That the plot which was allotted to the private respondent, it was a plot meant for allotment to the displaced person, isn't it?
Lordship is correct, yes.
Now we would like to know under what consideration you have settled it with the private respondent and whether that is permissible or not. Because your affidavit is totally silent with regard to that. We would like to know it. You see, is it for any charity purpose? Or have you taken the price of the plot from him? We would like to know it. Because if the land was meant for a particular purpose, how much liberty you would have to divert it and to allot it to private individual, and on what consideration? This court is interested to know it.
Lordship.
Because if we upheld the decision, this will basically give a seal of approval to your action, meaning thereby that those plots can be settled by the government to anyone and whatever were there. So that would lead to another thing.
It's a very, very valid query, Your Lordship. But Lordship, if I may just reply,
Yes.
of course we'll try to address the concern of the court. But Lordship,
No, we'll need you to file an affidavit stating us the things.
Lordship, yes. Lordship, two things. We are in this second round of litigation. In first round of litigation, first of all, the private respondent was not made a party. And so a very limited issue was the subject matter of consideration, that conduct a fresh inquiry, and we have done it. So in second round of litigation, the issue is only whether the inquiry was done as per law. So first thing, Lordship, would be that order first round was not set aside, nor challenged, but rather it was executed, and it's an issue of faith accompli. Now within second round, in the absence of any pleading, will the court go back? First thing.
See, we cannot see. It doesn't mean that our scope is confined only to the first round of litigation.
No, Lordship, not for a moment. I'm not saying the court should not even raise it.
The anxiety of the court is that the moment we upheld your decision, that would give a seal of approval to your decision.
Lordship, I'm
Meaning
coming to
thereby that those plots,
Yes.
which were meant for some specific purpose,
Lordship, correct.
can be utilized
Lordship,
for any other thing. And we'd also like to know then why you have extended that favor to the private respondent.
Lordship, as I said, first we have to overcome the hurdle. The first issue would be we have to overcome the hurdle. In the second round, in the absence of any pleading. Let's see how does the petitioner overcomes in answering the question. I'm not for a moment saying.
Are you trying to say that the court has to be confined with the inner
Lordship,
jurisdiction?
because the subject matter is very, very confined to only inquiry. Of course, the court can do it if court wants to do it, but then we have to overcome
This
that.
court is very much conscious of the status of the plot.
Lordship. Now addressing exactly the query. No, Lordship, not for a moment I'm saying that we will not consider it. But I'm saying that we need to address the larger issue. First is that we have to confine to inquiry in a second litigation. Second, Lordship, the plot, the concern of the court is whether this status was given to the refugees, can it be converted to private? Lordship, from 1950 till Justice A.P. Singh's judgment, they have annexed a copy of the judgment. Lordship, will kindly leisurely please go through the judgment. perhaps that will give us light in addressing the issue.
That Justice Eppishing's order doesn't give any authority to the state to allot the land free of cost to anyone.
Lordship is correct.
It
Now,
speaks about transferable and heritable right.
Lordship, absolutely
Conferment of
correct.
transferable heritable.
Lordship, absolutely correct. So the status from 1950 till Justice A.P. Singh judgment was, the land was directly allotted to the allottee whose number was there and whose status was refugee from erstwhile. So that relationship prior to Justice A.P. Singh was a fait accompli and was the subject matter. Now what has happened after Justice A.P. Singh judgment, Lordship, is this: the status of refugee and allotment number, that was done away with. Government was given a direction to kindly see the allottee involved there, and if they come and approach, to kindly from allottee you make it into a lessee. And we have annexed a copy, Lordship, and they also have annexed a copy of that. So all the allottees prior to Justice A.P. Singh judgment, their status was only allottee. Government could not collect revenue. Government could not decide if the heirs of the allottee would come, how would they be legalized. So government was losing lot of revenue. The allottees could not sell it, could not inherit it. But after A.P. Singh judgment, your status as allottee got converted into a lessee, and they could step into the shoe. Government could collect land revenue, and this was the normal revenue law in place. So once that status is acquired, Your Lordship, it is an admitted fact here that they choose not the allottee. First of all, never took position. Second, after Justice A.P. Singh judgment, they never
We are
approached.
talking about, see, that is okay. We are saying is what this court right at the beginning said,
Lordship.
keep apart the right of the petitioner here. We would like to know.
I'm just
See,
clarifying on that, Lordship. Just allow me to just conclude what I'm just trying to clarify. So after this status, his status as allottee got eclipsed by the revenue law. That is a watershed moment in Justice A.P. Singh judgment. So if that has happened, then Lordship is very clear. Now I'm coming to the query that Lordship has raised. If that has happened, then there is no bar for the government if the allottee never came, insofar as allottee is concerned, never came, because that status of the land, now government is wearing a different cloak of revenue law. There was no bar for the government to give it to the prospective lessee.
free of cost.
No, Lordship, not free of cost. Now the issue comes, a very limited query that the court has asked. We'll have to produce the report or we'll have to answer it. How the land was
give
given.
us just you take see because all this all this
For a moment, Your Lordship, just hurriedly, Your Lordship, I have just received an instruction. Treasury Challan number of 16/2/2022, payment of premium for Poksay Presbyterian Church amounting to rupees 47,356. So we'll come with a affidavit, Your Lordship, but just orally.
see because since this court doesn't
Your Lordship
want
is
to
correct.
give seal of approval
You are absolutely
to certain
correct,
action,
Your Lordship is correct.
you see the precedence of which may be dangerous, may bring dangerous consequences.
But Lordship, this query following
It
from the
doesn't
court.
mean that the court has accepted the.
No, Lordship is raising a very important and pertinent question, but this question would have been relevant before Justice A.P. Singh judgment. Before Justice A.P. Singh judgment, we could have.
Justice A.P. Singh's judgment, probably where there are individual holders of land, that will apply to them.
Yes.
The correction of this thing. But then what happens to the vacant part of the land?
Lordship, that would
And
be.
whether that judgment will confer a right on the state to settle that land in any manner they like.
Lordship is absolutely correct. We'll try to address the issue as to how the land was given to Presbyterian. I just read out this thing. Lordship will bring in an affidavit. But having said this, Lordship, as I said, we are in a second round of litigation.
We understand. You see, we understand. Mr. Lindo has already brought on record also
Yes,
that they
yes.
have never accepted it.
Yes.
It goes,
Yes.
no problem. But
Becau-
the
bec-
concern for the court remains is that is a plot which was primarily meant for like
The erstwhile,
accommodating, you see, extending relief and rehabilitation
Yes,
to those displaced now Bangladesh. I mean, like.
But
disposed-
Lordship, can I formulate a question now?
Yes.
After Justice A.P. Singh judgment, if the allottee prior to A.P. Singh judgment never came and got the lease executed, then there are two situations. A, it has remained vacant. After Justice A.P. Singh, the status of the land remains vacant. B, governed now, or it will be governed by the relief and rehabilitation notification of Government of India, or will it be governed by revenue allegation?
Exactly.
The moment revenue regulation applicable, Your Lordship, then government will have the power to allot.
Definitely. That is what we want to ascertain. Yes, Mr. Thapa, when Senior Counsel will be available?
Lord, since your Lordship has already indicated that they are to file this affidavit, well, let them. My Lord, the other question which.
See, we asked Mr. Khan, that is by implication, not passing.
My Lord may have it next week if.
Not an order, we are just giving.
Absolutely. Lordship is just
indication to
exchanging.
Mr. Khan
Yes,
that
Lord.
what
That's
he
why.
will have to face, the queries which he will have to
Yes.
face. He may have instruction, you see, at his wisdom, whether he wants it or not. The court has tentatively just expressed what it is.
Grateful, Your Lordship, yes.
Now, at the same time, since you are the petitioner, you also just let us know the background of allotment.
No, my Lord,
What was the condition incorporated?
Here, my Lord, two things. My Lord, like the way this respondent, the private respondent had approached the government, my Lord, similarly, my Lord, even the petitioner had also approached. Even before the land was allotted, the land was allotted to the private respondent, even the petitioner had approached. He had expressed his willingness to pay whatever is required to be.
Only flows from whether.
Absolutely, my Lord.
He
My
was
right
allowed
vis-a-vis,
your-
my Lord, my right vis-a-vis the.
Please, see, understand, there is a huge difference of status. You are a non-tribal, he is a tribal.
Correct.
Otherwise, there is no bar for the state to settle it with him.
No, I appreciate, my Lord.
That
My
is
right
so-
flows from my grandfather. I'm not an alien
That is,
to.
where, see, that is the area, that is the area which we have to determine. And
I will, my Lord, if
Mr. Lindo
Lordship
has brought in
allows.
certain documents which say that you have never accepted it.
No, my Lord,
So allotment, so that
may have been, my Lord, may have been. But
see,
I
there is a
have,
presumption
in
of
all,
correctness of the government record.
my Lord, in
So
all
once something
fairness,
comes from the-
me being the grandson of the original allottee, my Lord, I have a better title at least over respondent number 7, private respondent. I had made a similar approach to the government. The government accepted my challan, directed me to file challan also. I filed it midway, my Lord. My challan was thrown out and private respondent was brought in.
When did you file challan?
But prior to the respondent number,
No, that is
private respondent.
you cannot enter.
Of
into
course,
fresh
that is not a
transaction.
part of the record, my Lord, if
See,
your
you
Lordship
could not-
allows, because
you could not have entered into a fresh transaction with the government. Your
No, but-
right has to flow from your predecessor.
that difficulty was always there, my Lord. That is why I approached you.
If at all government allowed you to file challan also, that has no validity in law.
I'll confine myself to whatever is there in that case, my Lord. What Lordship has said.
Lordship, let it
That-
come next week.
Just give us a background also. What made you allot it to the
Lordship, yes.
private respondent? Why not to anybody else?
Absolutely.
Why he has been chosen there? What is the consideration? And if you have taken some money also from him for settlement,
Correct.
consideration, please let us know.
No, will. So let it come next week, Lordship. Let us see what.
Definitely, we would like to presence of senior counsel also will help
Yes,
us.
yes. If those things, if there's an order there, Lordship, then we'll see to it. But Your Lordship, Lordship will kindly agree at this stage. First, they have to overcome, as I said, the inquiry part and the.
That is okay. This court will take. See, we court is very much aware of what you are saying. Okay.
There are serious
There
issues.
may be two
Yes.
ways to see it. If they can establish right, maybe we go further.
The
If
moment,
not, then case.
absolutely. All other issues may not be relevant, Your
But
Lordship.
then this court perhaps thinks, since there will be a seal of approval, so it is required for the court to go into all these things. Otherwise, there cannot be a random allotment of any such land to any individual, and that we know what consideration is there. You see, you cannot do anything behind the back. You see, there must be a transparent, fair way of public, of government settlement. You see. There cannot-
Whether the public in general was at all invited to make similar claim as in the case of respondent number private
Lordship, the query
respondent.
flown from the court is very valid.
Since
but,
it is
but had it been their case in the writ petition, Your Lordship, challenge, we would have replied it by.
It is not there. You are correct. It is
they are
not
not
there.
replied.
It is not there. But then,
Nothing is.
if court wants, court may go into other aspects.
Absolutely.
Just say on prayer made on behalf of the learned senior counsel. Appearing for the petitioners who is stated to be unavailable. Come on. List is matter after 1 week.
let it be after 2 weeks, my Lord,
No,
since
2
they are
weeks will
come.
be
It's okay, Lordship.
after 2 weeks. Mr. Lindo, also you just see and just give us the background on what consideration the land was allotted to you. Okay. That you can give us. It should
All
not
right.
become a practice that government can allot it to anybody anytime if there is any other vacant land.
Okay.
We all are guided by law, isn't it? And that too also, if it is allotted free of cost and not for any public or charitable purpose, then it's a loss of revenue for the government also.
I'll find out it to Your Lordship now.
Just please give us, just help us, assist us to come to it.
Absolutely.
I'll oblige.
7,
Your Lordship, this.
Yes, Mr. Malangian.
Yes, Your Lordship. I'm withdrawing the petition, Your Lordship.
Okay. You think your problem is settled? Okay. On Mr. Marangi, learned counsel appearing for the petitioner on instruction submits that the petitioner does not wish to press this application and prays for permission to withdraw this the paragraph. One prayer being made, comma, this revision petition stands dismissed on withdrawal.
I'll oblige.
See, you argued well, but the only thing is that the averment in the plaint. Perhaps it is not permissible for this court to look into the documents and give, you see, or interpret it in certain way to negate the averment of the plaint.
Lordship.
That we cannot do. That is the limit of.
Lordship.
Otherwise, probably your argument is correct.
Yes, Lordship.
Nothing more.